Thank you all for having me here tonight. Thank you, Chairman Keeble. I want to be clear as I start my testimony tonight. First of all, my name is Heather Burbach. I am a staff attorney at Rhode Island Legal Services. I'm currently assigned to the Domestic Violence Restraining Order Calendar and Family Court, which is where I do my practice these days. Before that, I was with the DCYF calendar, have been various places at the Gary Heed building. But I want to be clear, I'm here tonight not taking a specific position about whether this bill should or shouldn't pass, partially because I'm not permitted to under federal law. But I am here tonight at the request of Representative Tanzi, who had the suspicion that there might be some questions about the procedures that happen in the court and what happens over at the family court for restraining orders on a regular basis. And so she asked me to come here tonight and provide some testimony that might clarify those sorts of issues. I want to be very clear about what my expertise is or is not. I am not a district court practitioner. I'm vaguely familiar with the district court procedures and what happens in district court and the interplay. I have, at a prior incarnation in my life, been a criminal defense attorney, so I do understand a lot of these things. But my knowledge and experience is largely in the family court venue. I will also start off by saying the clarifications that have been made with regard to what the law is and isn't and how the interplay of it happens, both by legislative counsel and most especially by Representative Knight that I've heard here tonight, I've not disagreed with any of it. And I want to be clear on that point. And for 2, let alone 3 lawyers to agree on anything is somewhat remarkable. So I want to note that. I did, however, so that we don't have too much lawyerly agreement, disagree with some of the comments from that you heard from Mr. Socio earlier this evening. Not because of his position, but because I noted that he gave a large number of hypotheticals, or not hypotheticals, but cases that he's familiar with and incidents that he's familiar with. And what I found interesting about each and every one of the situations that he described to the committee is that none of them would have been impacted by the bill that's in front of you. The situation where the woman, the young 18-year-old girl, was having a bad breakup, he got a restraining order against her, that was an ex parte order, and then she threw the clothes out the window, not impacted by this bill. This bill deals with after there has been a final order in a place or somebody who's convicted of domestic violence. So in that instance, it hadn't gone to a final order yet, so it doesn't fall into this bill yet. And there hadn't been a conviction, because some of what I've heard here this evening in dealing with the legal piece of it, as I say to many clients, if you mush everything together, it doesn't make a whole lot of sense, but if you break down each piece, it starts to make some sense. So the orders, as I read through the bill, that would be impacted are one of 3 things. Either a family court restraining order that has gone to a final order, a district court restraining order which has gone to a final order. Both of those are civil orders, or a criminal conviction generally out of district court. Those are 3 separate things. They can go in parallel, they can go simultaneously, they can go separately, but they are all separate things. The big difference, there's a lot of differences. One of the things that was discussed very early in this evening, and I'm going to try and be as brief as I can because we're all tired, that was discussed pretty early in the evening was the 2 bros scenario was what it was referred to. That is something that would not fall under a family court restraining order, because family court restraining orders have a more narrow definition of the relationship between the parties than the district court does. Family court, they do have to be family members, which is defined, and I have the statute pulled up in front of me so I got it right, as parents, present or former family members, which is spouse, former spouse, minor children, stepchildren, or parents who are related by blood or marriage, or individuals with a substantive dating relationship. And then there's factors for when that qualifies. And part of the reason that that's in there is not just because domestic violence isn't only amongst married people or legally related people, but it also happens in dating relationships, and it also happens in same-sex relationships. And so that's part of the reason that that's there. So family court restraining orders are a little bit different than the roommate scenario that was brought up earlier. And I think that the different provisions of the bill dealing with the different pieces of it. It could be made clear that, using one of the definitions, either the district court definition or the family court definition, might help clarify that piece of it. So that said, I have submitted some written testimony. My comments here are very different from my written testimony because I assumed you could all read my testimony. I didn't want to double take up time. My written testimony goes through the procedure for a family court restraining order and kind of what happens at the different steps that goes through there. There was some discussion earlier of what was referred to as the mutual restraining orders. Also, in a very related discussion, the Magistrate Shepherd Special, which is both of those things I'm going to lump together because I think they go together easily, are very different than the things that are being discussed in this bill. As I look at the bill, it requires the restraining orders be issued under specific statutes. And those specific statutes are laid out there. The Magistrate Special, which is the mutual restraining order, which is the situation where she said, okay, you stay away from him, you stay away from her, or vice versa. Everybody stays away from each other, and we're going to go on about our way, is issued under a very different provision of the law and in a very different way. So those are not the family court restraining orders that we're talking about under this bill. That is a separate, as Representative Knight, as Representative Knight absolutely adequately described it, come from the family court as a general court of equity and things that can happen as part of the remedies that they're allowed to issue that don't necessarily fall under the specific family court restraining order statute. And district court has similar though different pieces of it. And so we are only talking about a narrow band of restraining orders here. And these are the ones that have a different standard of proof, more or less. And frequently what I've heard Magistrate Shepherd, because she hears such a large majority of the family court restraining orders, I refer back to her even though she doesn't hear all of them by any means, is she'll say, look, I know something happened here, but I can't make findings that there was a specific incident that gives rise to a restraining order, so I'm going to issue this under a different provision. And she actually has a whole different form. There was discussion about the Ronco system earlier and the failings of the Ronco system, the problems with the Ronco system. To be clear, nothing in this bill is furthering, taking away, or creating new problems in the Ronco system. The Ronco system has improved a lot over the years. It still has its failings, and it is an entirely separate failing than what this bill is addressing. So I don't want us to go after too many red herrings here. Those civil restraining order, or the civil restraining orders, which is different than what I'm referring to as the family court or district restraining orders, these ones that are being given under different provisions. Those are an entirely different beast than what is being dealt with in this statute. They would be excluded. They would be excluded from this statute. There's a couple of different ways that they come up most frequently in the family court. Number one is what we've heard about, which is the judge has decided, or the people sometimes agree to these sorts of orders, saying, you know what, we're not going to say that this is something that needs to be punishable by criminal sanctions, and that we're going to deal with this as a civil order that the court will enforce as an agreement between the parties. So there's that way that it comes up. Also, frequently in the divorce and custody context, you can have a family court restraining order, the specific definition that this would talk about. However, frequently what happens in those cases, both in my experience, anecdotally, and what I've seen from various judges and magistrates, is if somebody has brought a restraining order case at the same time as a divorce in custody, the family court will assign those to be heard by the same judge at the same time, so that it's all being heard together. And quite frequently what happens is, in exchange for dismissal of the restraining order case, an order is entered in the divorce or the custody saying the parties are going to, not have any communications other than about X issue, whether that be the child or the dog or whatever the specific issues that they're going to be about. Those sorts of orders and those sorts of agreements, under my reading, would not fall under this bill today. that this bill is a lot more narrow than that. It is only dealing with the classical domestic violence restraining orders, either from the district court, from the family court, or from a conviction of a domestic violence crime. Finally, and then I'm going to move on because I think you all are tired enough that you deserve a break. We
still have 30 or more witnesses to go, so.
My condolences. I think they're all going to say very important things, and I think it's going to be important. I just know it's going to be a long night. I want to be clear on what I mean by that. The final thing is, as I read the bill, the district court restraining order and the family court restraining order, those are the prohibitions on gun ownerships for the period of the order. So if the order is a 3-year order, it is a 3-year prohibition. If the order is a 1-year order, or even I've entered orders as short as 1 week, that prohibition would only last for the period of that order. The time that it would be a lifetime prohibition would be once there has been a domestic violence conviction of a crime. So now we've got a judge that has looked at the matter and determined that there has been a beyond a reasonable doubt standard met. That has either been agreed to through a no-low plea, a guilty plea, or conviction after trial. So those are the only instances, as I read the bill, that would imply the lifetime ban on weapons ownership. I hope that I have clarified. I have learned that I frequently think that I have and didn't. I am open to any questions from the committee. I have also, on my written testimony, attached my contact information if someone wants to follow up with me separately other than in this forum.
Okay, any questions for Heather? Heather, in criminal proceedings, sometimes when, I think always, judges inform the defendant before accepting a plea that it could have collateral consequences. For example, with immigration. Do you think it would be appropriate for us to include in the bill a requirement that the judge inform the defendant so that the defendant has knowledge that he or she will be prohibited from owning weapons for a lifetime?
As I stated,
as part of their plea.
As I stated briefly, once upon a time, I was a criminal defense attorney. And as a criminal defense attorney, I would say absolutely, the more potential collateral consequences that my client would know about before they enter a plea or after they enter a plea even, the better. And I think, frankly, when you have domestic violence abusers, because after there's been a plea, they're being found to be an abuser, so I'm going to call them that. If you're having domestic violence abusers knowing that they can't own firearms, I think that makes everybody safer. If that's what the legislature's determination has been, is that it would be safer and better for the populace that these people not have firearms, telling them that is not a problem in my book. I speak for myself on that, but I generally don't believe giving people information is a bad idea.
Any other questions for Heather?
I do want to follow up just because one thing I didn't mention, the situation that you discussed during Sarah's testimony a few minutes ago about how could that possibly have not been a criminal case that you brought up. I agree very much with what Representative Knight said, and I just want to clarify a little bit. It very well may have been a criminal case too.
Is it possible that in the criminal case there was an order to relinquish guns, and that's why it wasn't done in the family court?
The possibilities are endless. That is absolutely one of them. I will say one thing that this bill does that is actually not part of the current law is it provides some procedures, both for the court to ensure that the firearms have actually been surrendered when they've been ordered, which is not part of current law, and I'll explain that in just a moment, but also for after an expiration for the people to have a procedure to get the firearms back, which also doesn't currently exist and can create problems themselves. When I say that there isn't a follow-up procedure, literally within the past week I've been in court, and this is not anomalous at all, where somebody was saying, this person isn't supposed to have had firearms or was ordered by another judge to give up firearms and never did. And that was the testimony that was being given, and there was no contradiction to it at all. And so the judge said, well, I'll order it again. But it's an order, and it's kind of an honor system that we're going to trust that you do, and you may or may, the only way we will know otherwise is if they get caught having a firearm with someone recognizing that prohibition's in place. So there's some carrots and sticks in there for both sides that aren't there currently.
Okay. Thank you, Heather. Any further questions? Thank you so much for your testimony.